The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Good morning. I understand we have a group of kids here from Audubon, so welcome. We hope you enjoy your opportunity to watch the Iowa Supreme Court in action. We're here today for 3 cases. 2 of them will be submitted by oral submission, which is our first case will be the case of Gray versus Oliver Law Firm. And then the second case that will be heard by oral argument is State versus Montreal Shorter. The third case is State of Iowa versus Eddie DeLong, and it is submitted at this time without oral argument. So we will start with the Gray case, and in particular, I believe Jonathan Kramer is here. Jonathan Kramer, you may begin.
Thank you, Your Honors. Good morning. May it please the Court, Counsel. My name is Jonathan Kramer, and I represent the appellants and plaintiffs, Jeff Gray, Janice Gray, and J.G., their daughter, as successors in interest to James Lee Hohenschel. Mr. Hohenschel made a horrible decision and decided to rape a young girl, but that is not at all what this case is about. Although Mr. Hohenschel is a number of different things, he was also a client. And this case results from his relationship with his former counsel as a client. When Mr. Hohenschel hired an attorney to defend him and to advise him and counsel him about his rights associated with the legal issues that he had, he was entitled to the same protections and candor, standard of care that this court has imposed on attorneys for all of time. And this case results from that. The reason why we're here specifically today is because the district court decided to create out of whole cloth a ban on the assignment of malpractice claims exclusively against lawyers. And the Grays do not agree that that is
You say
correct.
out of whole cloth, but isn't that the majority rule in other jurisdictions?
I understand that there are lots of jurisdictions that have found that there are public policy concerns. None of those jurisdictions have Iowa's history. Specifically, the number one case that all of the other jurisdictions really start from is that Godley versus Wank and Wank case out of California. The huge and crucial difference between Iowa and California is that California followed the original common law that personal injury types of cases are not assignable, but contract cases are. Iowa departed from that common law statutorily forever ago, and that was reaffirmed in that Klink case, Fisher versus Klink in 1944. Iowa has not adopted that concept that there is a distinction between personal injury versus contract claims. We have instead said all chosen action are the same, they all should be treated the same, and that was codified in 626 Spot 21.
If we were to conclude that the claim could go forward, how would you prove damages in the suit?
I don't know what all of the facts eventually would be, but I would say the fundamental crux of where I expect the case is likely to go is that that Mr. Hohenschel, had he understood the complete lack of defense strategy and the complete inability to actually defend himself at trial, would have instead decided to go down a settlement path and would have actually responded to the settlement overtures that would have avoided trial in the first place. Had he done that, it is certain that his total liability would have been substantially less than his existing liability.
Isn't the attorney able to raise as a defense in the malpractice that it doesn't matter whether the liability would have been $1 million, $2 million, or $10 million, Mr. Hohenschel couldn't have paid it? So no harm, no foul. Isn't that a defense the attorney has?
I don't think that actually is a defense under Iowa law, but we never got to in that spot. So it's hard for me to speculate about where things would have gone in the case eventually. We didn't get there. The district court instead decided that we weren't allowed to do any discovery of any kind.
Your position is in the attorney malpractice, even though the difference from the perspective of how your client's recovery against Mr. Hohenschel between $1 million, $2 million, and $10 million would have been negligible. If you turn it into a malpractice case, that difference might matter. Is that your position?
My position is that I understand Iowa law to be that as a result of a lawyer's actions or any person's actions, if you increase the debt of your client and that was caused by malpractice, then that is potentially a recoverable damage. Yes.
But don't you see that in a way puts you in a better position with the malpractice claim than you were with your original claim? Because I assume on your original claim, Mr. Hohenschel is judgment proof. He's in prison. Isn't that right?
My understanding is no. He's out and working as far as that goes. He served his time, as I understand it. But I don't have all of the facts on that to be able to say. Yes, I don't believe that there's any doubt that based on the existing judgment, Mr. Hohenschel would be insolvent.
But don't at some point in your damages case on this claim, you have to argue that the original award was not legally justified?
Absolutely not. And the Grays would never argue that. I think that we agree that there would be some level of disingenuousness if we were to try to attack the jury award in any way. The jury entered in its award. It determined what those damages were based on the existing facts, and at no point have the Grays ever attempted to assert or actually asserted in this record or otherwise that there is anything incorrect about the award that was given. The issue is, rather than Mr. Hohenschel being in a position where he could have effectively determined his own fate and made under some agreement that makes sense based on his position, instead he went from owing some money to one of the largest judgments in the history of Iowa and adding all of the notoriety associated with that.
When I began reading the briefs in your case, I had to read it and reread it and try and figure out who's on first. It's not as easy to grasp as I think you're attempting to persuade me, at least. What I'm wondering about is, unfortunately for you, I probably have seen more parents in a bad situation as a prior juvenile judge where parents have perhaps used their own child in exchange for drugs. They would allow their child to be used in a deviant way in exchange for drugs. There are bad parents out there. These parents, I am not saying, are that way. What I'm saying is, if we allow this, aren't we providing an opportunity for people to game our system when you allow an adversarial position to make money? For example, that case that I just gave you where a parent allowed the child to be taken advantage of for drugs. If there had been an eventual lawsuit, they could also try and do what you're doing. So I'm looking at the policy of it as far as whether or not this is something that we want to engage in.
I appreciate Justice's question. I don't know that I totally follow, so I'm going to do my best to try to understand. I think that what you said was that there are circumstances out there where you might have parents that affirmatively act in order to harm their children.
Not just parents. I use that as an example.
Okay,
but when we're talking about an adversarial position, because what Justice McDonald was getting at is, aren't you going to have to kind of switch ships here midway?
And I'm sorry, I guess I just don't follow the logic. It is I guess I'll say it this way. Let's just assume, for our purposes, Mr. Hohenschel was actually harmed by his counsel, that his counsel, rather than defending the client to the best of his ability, instead limited the information that went to Mr. Hohenschel because he needed the hourly rate. He needed the case because of his own personal gains and personal needs. Let's just assume that's the case for the second. Mr. Hohenschel is not the kind of person that any one of us would try to represent on a contingent fee basis, right? So how is that accountability for that lawyer in that circumstance with respect to that client, just because the client is, in this case, a criminal, are we allowed to exploit that client in that circumstance? And I'm saying that what we know here is that there is some accountability issue. Mr. Hohenschel can't afford to pursue his own attorney. Mr. Hohenschel can't get a lawyer to go on a contingent fee basis because of the catastrophic debt.
Why can't your clients just pay for his lawyer?
Potentially could. The issue is, from a defense counsel perspective, defense counsel say no but, right? That's their whole job. If we have an agreement with Mr. Hohenschel prior to bringing a case, then the defense counsel argues collusion. If we wait until we bring the case and then have the results come out otherwise, then they say it's a lack of assignment.
It strikes me you can get around the assignment if Mr. Hohenschel cooperates. You just say, well, we'll front the money for your lawyer. You could sue. What troubles me is kind of taking him out of the picture as we had earlier in the dialogue, and then you somehow end up better off because you're pursuing a malpractice claim than the original claim would have been. The original underlying claim would have been by Mr. Hohenschel against his client.
I really see them as two distinct harms, right? The harm between Mr. Hohenschel and, in this case, JG and the Grays has one set of facts, it has one set of elements, it has one ultimate result in terms of damage. What we're talking about here today is exclusively whether or not Mr. Hohenschel, as a victim, as a client, was harmed by his counsel. Definitely it may come out in the ultimate trial that he can't show damages or that we can't show damages on his behalf. But it also could be that we can. In the case here, the district court said it doesn't matter what the facts are. No matter how egregious the malpractice is, there's an absolute ban on the assignment of this malpractice case because it's against a lawyer.
So what's troubling me a little bit is seemingly inconsistent positions. And I know that your theory now is that it could have been settled. You wouldn't have to attack the jury verdict. But I want to read you something from the Grays, a brief on the punitive damages award. And it says, the appellant is asking this court to agree with him that while raping a child may not be good, but it's not $127 million bad. He is further asking this court, if the court agrees with this astounding assertion, it should substitute its judgment, yada, yada, yada. Appellees believe this assertion request is abhorrent, contrary to the very tenets upon which civil justice system was created and cultivated, and an affront to justice. And so now you bring this case, and your position is actually that jury verdict shouldn't have been had, that this is more like a $2 million malpractice claim, and it should have been settled for $2 million. Those seem very inconsistent to me.
Your Honor, I'm not sure I caught it. Did you say you read that from the appellant? I'm sorry, the appellant brief on the underlying personal injury case? Okay, so Mr. Gorley's brief is, in my mind, that's the primary counsel. And in that time, I understand what you just read. Mr. Gorley was arguing to this court that there was nothing wrong with the jury award or the punitive damage award. And I guess I'm saying exactly the same thing. The Grays are not arguing under any circumstance that there was anything incorrect or improper about the jury's award in that case. Whatever damage...
No, you are saying that. You are saying if the plaintiff now, or the person who's a claim, had competent legal representation, that this jury award should have never happened. And that's your measure of damages, is the amount of incompetence that attributed to a jury award, which in the other case you said is wholly justified, and any reduction of it would be an affront to justice. That seems very inconsistent to me.
And I guess I don't see that inconsistency. In my mind, if I, as an attorney, can see a path where my client can get out of a case and reduce their exposure for 10% of what a plaintiff is asking for, and that makes sense to me, then I think I have an obligation to try to encourage that. And by not doing that, and so allowing my client to have the full exposure that a plaintiff is asking for, is a malpractice.
Is there any evidence in the record that Hohenschel could have paid a $2 million settlement?
No, Your Honor.
Well, I mean, in a legal malpractice case, you have to prove a case within a case. You have to prove the lawyer breached a duty, and that the damages that flow from that are what you would have gotten if he had not breached the duty. And if the client is judgment proof, you end up in the same place, zero recovery, right?
We were not allowed to do discovery because the court, kind of dismissed the case with prejudice prior to that. So I really don't have the ability to have a record that I would have liked to have given. But again, I think that the increase of debt or decrease of debt, this court has said is a potential actionable damage, and we were proceeding on that basis.
But related to Justice Waterman's question, what's the evidence that your current clients, the Grays, would have accepted a $2 million judgment.
There is, I believe, a letter in the record that was a offer to accept a confession of judgment with no payment terms as part of the case. There was no response to that. That was all also discussed, I believe, in the petition and kind of the summary judgment documents. So it is there. There's definitely a settlement letter that was never responded to by Mr. Oliver.
You made a statement to Justice McDonald that the discovery was not allowed. Okay, it may not have been allowed. And maybe it's in the record. Did Mr. Hohenzoll ever allow himself to be deposed just one-on-one with these people? Or has he denied or been totally unavailable?
No, it's not in the record. Definitely Mr. Hohenzoll has made himself available. I've had personal discussions with him prior to his obtaining new counsel, encouraged him to get new counsel. Mr. Howey represented him. And so I was working through Mr. Howey on how we were going to proceed once the court entered the protective order that prohibited effectively all contact relating to this case or relating to any question that could conceivably result in something about the attorney-client relationship at all. Then it just kind of ended.
I'd like to ask one more question. I'm confused. Is it your position that the damage issue is not before the court today? Or is it your position that we should address the merits of it?
No, it is my position that the damage issue is definitely not before the court today. As far as the court today, the only thing that's happened so far is that the district court disallowed all discovery, and the district court determined that there was an absolute ban where this assignment is treated totally differently than this court unanimously dealt with in Red Giant Oil versus Lawler, in the Klink case, and under 626.21. All of those other recitations of Iowa law relating to public policy are effectively overruled by this existing ruling. And we believe that the fact issue, that it's exactly the opposite. Not only is there not a ban, there is absolutely no prohibition as to what has happened here. We understand that the malpractice claim is not an automatic, right? We have to, as plaintiffs, eventually show that there is a waiver of privilege. Otherwise, it would eventually be unfair to Mr. Oliver.
You may sum up.
I'm sorry. Oh, I'm sorry. Yes, thank you, Your Honor. In addition to those issues, we have argued in the briefs that this is an unnecessary, that this is something that a trial court absolutely can address as it goes through the normal process. This kind of arbitrary and additional ban we think is unnecessary, and we would encourage the court to review the analysis in the McCann case particularly. Thank you.
Thank you. Mr. Cacciatore.
Thank you, Your Honor. May it please the court, counsel. The question before this court is narrow. The question is simply, may a legal malpractice claim be involuntarily assigned?
Let me stop you there real quickly. We've had a lot of discussion about damages, and you heard the brief colloquy saying the damages is not before the court. What's your position on that?
Well, the damages issue is not strictly before the court. I would say that the damages issue is relevant insofar as Justice McDonald has indicated there's a reversal of positions. That the Grays claimed in the underlying litigation that they were owed tens of millions of dollars as a result of Mr. Hohenschell's crimes. And now they're claiming they were not authentically entitled to the verdict rendered, but that the verdict was rendered due to Mr. Oliver's breach of the standard of care.
Isn't the damages issue also relevant in determining the public policy considerations that drive whether to make such claims assignable or not? Because as I understand the Grays Counsel, their position is that they could potentially do better they could potentially get a recovery via malpractice claim even for a difference in an amount that would be irrelevant as far as the claim against Mr. Hohenschell is concerned. In other words, the malpractice claim could leave them better off than they would have been if the counsel for Mr. Hohenschell had performed perfectly.
Well, that's exactly.
Isn't that maybe a reason not to allow assignability?
Well, I think it is a reason not to allow assignability. That it transforms the defense lawyer into the insurance carrier. That the defense lawyer now becomes an insurer for the client. That there is somehow now a duty of indemnification that never existed before. It's an important point.
The attorney has to breach a duty, but still it does create a situation where a malpractice that made really no difference vis-a-vis between the Grays and Mr. Hohenschel now makes a difference in the malpractice litigation.
I think it's an important point because the Grays are not seeking to hold Mr. Oliver accountable or to vindicate Hohenschel's rights. They're trying to collect a judgment. That's what this is. This is a collection action. And so, all of the high-minded ideals about accountability kind of fall by the wayside. What has happened is the Grays understand that Mr. Hohenschel is judgment-proof, and they understood it all along. And they went forward with this trial, and they got a big judgment. And one can ask whether anyone could have avoided a large verdict given the admission that Mr. Hohenschel made in connection with the criminal matter, that he admitted he pled guilty to lascivious acts and to serving alcohol to a minor. Under those circumstances, liability was established, and the only question was damages. And so they go to trial, and they get a big verdict, as you might expect. And so I think everyone, in fact, in the trial record, there's argument from Mr. Gorley to the jury, don't worry about whether this can ever be paid. That's not your concern. A message has to be sent, and you have to focus on what number would make sense in terms of the harm to this child. And the jury sent that message.
So even assuming it's true that there's public policy reasons not to allow assignability, why wouldn't that be the legislature's decision to put a limitation in the execution statute?
Well, what I can tell you, Your Honor, is that 21 jurisdictions have considered the very same issue. 20 of them have come down on the side of prohibiting this based on public policy grounds. And there are very practical reasons why this court should consider those public policy reasons. I think the primary practical implication is the issue of privilege. And
well, I understand the policy arguments, but just as a matter of statutory text, we have an execution statute that allows for execution and levy on choses in action. There's no carve-out for any particular type of claim. Our common law history is that that's been construed fairly broadly. Would you disagree with that?
I don't disagree with that.
So why not allow the legislature to address the issue if they think that this kind of action is improper?
Because the legislature because we don't need a legislative enactment for this reason. There is no claim. There is no chosen action to execute upon. Mr. Hohenschel has never asserted a claim. He's never made any sort of overture that he thinks his lawyer committed malpractice, that he would like to make a claim, or that he would like to cooperate with the Grays. And so I don't know.
That's a different point, and maybe you're arguing this point that this hasn't even ripened into something upon which they could have executed. Is that the argument you're making?
Here's the argument I'm making. I don't think that a judgment creditor can create property, fabricate property, by simply filing papers where they purport to execute on a never asserted claim. A legal malpractice claim is personal in nature because the privilege is personal in nature. And in fact, this court has determined in the Bump case that you can't force legal counsel upon someone involuntarily, that the right to choose legal counsel is personal in nature, and that claims are personal, and that this sort of claim would be personal in nature. The Grays, we think, don't get to unilaterally determine that there's a malpractice claim here, that the client has to be involved in that in some fashion.
I mean, couldn't the Grays accomplish the same thing, following up on Justice McDonald's question? Couldn't they file an involuntary bankruptcy against Mr. Hohenschel? I mean, debt's non-dischargeable anyways, but you could file an involuntary, get a trustee appointed, and then tell the trustee you want to buy the claim. I mean, there's other ways to skin the cat than a sheriff's sale, right?
I don't know. There are cases, bankruptcy cases, that hold that a legal malpractice claim may not be assigned in bankruptcy for the same public policy reasons.
I think you're right, but I mean the point being that it's your point about creating property rights. You could file a bankruptcy and then go to the trustee, and it would be the trustee's decision, and maybe they would choose to recognize a claim and assign it to the Grays.
Well, at least in that case, you would have a trustee stepping into the shoes of the client to evaluate the situation, rather than a litigation adversary who is not just an outsider to the attorney-client relationship. They are an adversary to that attorney-client relationship. They are outright hostile to it. They should not be allowed to make decisions for their adversary. I would have more confidence in a bankruptcy trustee to make those determinations than a litigation adversary who has absolutely no interest in protecting Mr. Hohenschel's rights. That's not why they're here. They claim that Mr. Hohenschel victimized, and the jury found that Mr. Hohenschel victimized the plaintiff in that case.
What if we change the facts and Hohenschel, the client, voluntarily assigned his malpractice claim? Could this go forward?
Yeah, it's a great question, Your Honor. Most of the cases that deal with a voluntary assignment also find a prohibition based on public policy. Of course, the difference is that in the voluntary situation, at least the client has waived the privilege, or we would assume so. If they're voluntarily assigning the claim, they would have to waive the privilege. I think the argument is stronger, quite frankly, if the assignment were voluntary. But I don't know that would get the Grays there, because there's still this problem of the role reversal and the problem of undermining the integrity of the legal system. One of the courts phrased it as when a plaintiff brings this kind of claim, they're claiming that to the extent they were not entitled to recover, they are now entitled to recover. And you have that problem whether or not it's voluntary or involuntary. Also, there's a problem of collusion, where you're going to have adverse parties colluding against the defendant's attorney by either stipulating the damages or basically the judgment debtor finding a way to extricate himself or herself from the situation by basically turning against their own attorney. And I just think that's not a situation that is going to be helpful to the legal system and to clients in the long run. It's going to undermine attorney-client relationships.
If we allow this lawsuit to go forward, what impact would that have on the Iowa legal system's ability to get lawyers to represent indigent clients? Would that have a chilling effect?
I think it'd be devastating. I mean, I can't imagine any lawyer wanting to take on an indigent client. Mr. Oliver, I want to mention, he's not able to defend himself against the allegations that Mr. Kramer made before this court because privilege hasn't been waived. So I can't tell you what happened in the underlying matter. What I can say is that Mr. Oliver vindicated kind of the cherished notion that lawyers are supposed to represent unpopular causes and clients. And now he's being punished for that. So I think, Your Honor, I think there are several layers, and I could probably speak for a half hour just on that issue, but I do think it would have a very chilling effect on the ability to obtain legal counsel for the uninsured, the underinsured, and the indigent. And I think at a time when I know this court has recognized the problem that we have with the affordability of legal counsel and the access to the courts, that's an important issue.
Sounds like you don't think there should be a malpractice action against people who represent indigent clients.
No, I'm not saying that at all. I think that
same policy reasons apply. I mean, you wouldn't want to engage in that kind of representation because you might get sued.
No, what I would say is that it adds an additional layer of unnecessary risk if I have to worry not just about my client being dissatisfied, but my adversary. And of course, the adversary would have every incentive in the world to try to turn a judgment-proof situation into a collectible situation by looking to the adversary's attorney, where the adversary is judgment-proof. It's an important point, Justice Appel, that nothing in what I say should be construed as that Mr. Hohenschel should not be able to bring a malpractice action in his own right. He's obtained, as Mr. Kramer indicated, he's obtained independent legal counsel who represented him in the appeal in the underlying case. Mr. Kramer has had communications with Mr. Howey, as have I. Mr. Hohenschel knows how to find a lawyer, and he has independent legal counsel to advise him as to whether Mr. Oliver committed malpractice, whether there is a viable case, and whether that case should be brought.
Let me ask you, I'm sorry to interrupt you, but let me ask a question analytically. Your adversary suggests that under Iowa law, tort claims have been assignable for decades at least. Seems to be right. And he asserts that general principle undermines the case law that you've cited. Why don't you give us your response?
Well, the distinction between contract and tort has long gone by the wayside. This is examined by virtually every court under the rubric of public policy. And so I don't think that the contract-tort distinction matters at all. I think that the privilege issue here makes this different than, for example, a car accident case that might be assigned. I also think that the role reversal problem makes this much different than the assignment of a garden variety tort claim. I think that there are a number of other distinctions. The availability of legal counsel to the indigent, the uninsured, et cetera, is not implicated in those other situations. I think that the adversarial nature of the legal system makes this different than your garden variety assignment of a tort claim. That you get into all these issues of privilege, role reversal, the integrity of the legal system, the availability of and access to the courts. None of those things are implicated, or very few of those things would be implicated in your garden variety assignment of a tort claim. So clearly, and again, I think 19 or 20 jurisdictions have analyzed it that way. And all but one, there's a case in New York that I found where there was, the court allowed an assignment of both an insurance bad faith claim and a legal malpractice claim as sort of a package. And I didn't find any case that overruled it, so I'm assuming that that's still good law in New York. But otherwise, the other 20 jurisdictions have prohibited this based on public policy in the specific context of legal malpractice.
Mr. Cacciatore, you may wrap up.
Thank you, Your Honor. I think I've covered most of the points here. I do want to distinguish this case from the Red Giant case because that was cited by...
You may briefly do so.
Oh, I'm sorry. I see
okay.
that my time is up. I've concluded. Thank you, Your Honor.
Thank you. Mr. Kramer?
Thank you, Your Honors. There are really two more points that I would like to make in rebuttal. First is to talk about privilege, and second is kind of an all-or-nothing discussion. With respect to privilege, we all understand that in order for Mr. Oliver to properly be able to defend a malpractice case, there has to be a waiver of privilege. The Grays have never taken a different position, and they have not asserted that that privilege has yet been waived. But they also understand that they believe that that privilege will be waived, which is a voluntary act that is specifically voluntary on behalf of the client. We are not suggesting that we can move forward with the action and get past a summary judgment level if we don't get a waiver of privilege. In this case, there hasn't been a waiver of privilege yet, but it's because I couldn't go and get the waiver of privilege that I needed, again, in order to avoid the collusion issues. And so it's the fact and the procedural issues here that have prevented Mr. Hohenschell's ability to be able to advise this court what his position truly is as client, to the extent that that part is not assignable. Justice Mansfield raised the bankruptcy concept. A bankruptcy trustee doesn't get any more waiver of privilege than anybody else gets a waiver of privilege in a bank.
Sure about that?
Yes, Your Honor. Unless it's in a corporate context. In a corporate context, the privilege goes to the entity, and so that gets assigned. But if you have a person that has pre-bankruptcy counsel and they have a privilege that's there, the bankruptcy trustee doesn't get to just waive that.
I'm not sure I agree with you, but go ahead.
Okay. That's my understanding. That's my understanding.
How about the notion that this isn't an ordinary garden variety tort? I mean, you heard the colloquy I had with Mr. Cacciatore toward the end. It is correct that Iowa has tossed over the distinction in terms of assignability. Indeed, that seems to be the trend. I mean, we were kind of one of the first jurisdictions maybe to do it, but I think that's fallen to the wayside. But it seems to me this has different features than the automobile accident. But why don't you respond?
Thank you, Your Honor. And that gets really segues right into my second point, which is that this is really an all-or-nothing kind of issue, right? It is very difficult for this court to be able to try to assess all of the different ways that assignments can happen, right? If you say you can't assign exactly to an adversary, well, what if Mr. Hohenschell assigned it to his dad, who then assigns it to an adversary? Or what if you do a partial assignment as part of litigation funding, which is also absolutely the trend right now? What about we've got this privilege issue in a legal case, but we don't have a similar rule for doctors or priests or accountants who also have the same kinds of privilege issues. So it really becomes a much broader all-or-none related issue. And then the question
of those examples you just cited, all of those involve voluntary transfers. What is your best case regarding the involuntary assignment of a legal malpractice action to an adversary?
I'm sorry, ask the question one more time.
What is your best case that stands for the proposition that there can be an involuntary assignment of a malpractice action to an adversary?
I think the only case that may have gotten there was that Southern District of New York case, federal case. I don't remember the name of the case, but there is one. It's cited in both briefs. I believe that that's the only one that says assignments every single time, no matter what.
Would you agree that the other jurisdictions that have considered the exact issue of involuntary assignments of malpractice claims to adversaries disagree with that New York result?
I can't speak to that. I think, in my mind, almost all of the cases that were out there really focus on the history from the Gank case, that Godley case, which is based on a completely different analysis, and then kind of following that as being the majority rule. The cases that I read that really seemed to go into the detail about the various policies were really the McCann case and that, I think it's a Thorsten case, and those bucked the trend, in my opinion. So, again, every court can only deal with the case that's before it, and so if those cases weren't exactly the same facts as here, then it's not going to apply in the exact limited context. Only in Iowa do we have Red Giant and the 626.21 that talks about all.
Red Giant was a voluntary assignment by the insured against an insurance company, which by definition is already insuring the risk. A defense lawyer doesn't insure the risk of the underlying transaction, right? So I don't see how Red Giant helps you.
Red Giant, with the analysis that this court used in Red Giant was that because you can do an involuntary transfer, then it makes sense to be able to do a voluntary transfer, and more importantly, that the whole concept of fraud and collusion that may ever happen isn't a reason to not address a specific harm currently. Thank you, Your Honors.
Case of Gray versus Oliver is now submitted.